Hi, my name is Erasmus Baxter. I'm a senior journalism major at Western Washington University. I'm the former editor of the Western Front, the campus publication, and AS Review, which is another publication on campus. We're joined today by Mike Heisten, the senior legal counsel for the Student Press Law Center, who's been advising us on this matter. And Asia Fields, who's the third plaintiff in our lawsuit, couldn't make it today because she's graduated and is off doing journalism. So the way this is going to work, Julia and Mike are each going to give a brief statement, and then we're going to take questions at the end, and then we'll be available for interviews afterwards.
And my name is Julia Furukawa. I'm also a former editor-in-chief of the Western Front, and here we go. As journalists, we're committed to transparency. That's something we've been taught since our first day in classes here. That means thorough, thoughtful reporting and a pledge to keep the public informed. Over the past few years, we've applied these skills to report on instances of sexual assault and misconduct at Western, sharing stories of the investigative process and the survivors who felt it let them down. In 2017, my co-plaintiffs, Erasmus and Asia, reported that Western had readmitted a student convicted of sexual assault, spurring protests on campus. Further reporting revealed that this was not an isolated incident. The university allowed another student found responsible for sexual assault to return to campus, forcing the survivor to endure seeing him if she wanted to continue her education. However, we learned of those cases by chance. Using the skills we learned in class, we filed a public records request for the final results of Western's investigations into allegations of sexual misconduct, including the names of students found responsible. We sought that information in an effort to understand if this was a trend and whether perpetrators of violence had gone on to do further harm. Upon receiving the records, the names were redacted. Over the last 2 years, we've tried to convince Western to follow the law and release the names, but to no avail. When we met with Vice President Melinda Husky, we were told Western couldn't release the names because the administration was afraid of being sued. However, this was a choice. We told them in October of last year that we intended to pursue legal action. They chose to face a definite lawsuit from student journalists rather than face the off chance they might be sued by a perpetrator of sexual violence for releasing their name, something the University of Washington has already done. The university has offered shifting legal explanations for their decision. They've repeatedly cited federal privacy law as the reason they can't release the names, an argument already struck down by a court in North Carolina when student journalists there requested similar records. Then, when we requested the names again after meeting with Husky, administration cited an entirely separate exemption, one that our lawyer tells us has been misapplied. So, on May 6th, we filed a lawsuit against Western in Whatcom County Superior Court with William Crittenden, our lawyer who specializes in public records law. The point of getting these names is not vindictive. It's to ensure that the systems intended to provide justice on campus are working correctly, that no group of students is being disproportionately sanctioned, and that the process is fair to both survivors and the accused. Western's handling of sexual assault cases has repeatedly shown to be flawed, and the best way for administration to rebuild trust is with transparency and accountability and releasing the names.
Right. My name is Mike Heisten. I am an attorney and senior legal counsel for the nonprofit Student Press Law Center. I've been working on issues related to access to campus crime information for my entire career, which is close to 30 years. During that time, schools across the country, often acting with the blessing of the U.S. Department of Education, have fought tooth and nail to keep a lid on campus crime information. Information that can paint a much different picture of campus life than that's presented in a school's glossy brochures and marketing materials. In the early 90s, the battle was over access to campus police records. Schools across the country, following the lead of the U.S. Department of Education, began to claim that records compiled by campus police officials, records of serious crimes such as robbery and sexual assault, were education records protected from disclosure by federal and in some cases state law. That remained their position until they were successfully sued, and the law was changed to make clear that campus police records were just that, police records documenting criminal conduct, not education records. The battle moved then to these things we call campus courts, or campus judicial bodies, and it's such a curious system. The campus court system, most widely used today by schools across the country, panels with a mix of some students, faculty members, sometimes hearing officers, largely came into existence during the 1960s. For many years, these disciplinary bodies busied themselves mainly with cases regarding violations of campus rules and campus academic standards, such as cheating and plagiarism. But over time, their jurisdiction has morphed. The public is often amazed to learn that these bodies now handle complaints involving conduct that would be a felony, carrying significant prison time if pursued in a traditional criminal justice system. Western Washington University handles rape cases, and they do it behind closed doors. And they keep much of what they do secret, citing education privacy laws that were intended to protect student transcripts and test scores. The structure of campus courts is not like a court of law. There is, for instance, no formal evidence gathering, known as discovery, no cross-examination, and no power to issue subpoenas. Traditional rules of evidence typically don't exist, and participation of witnesses is generally voluntary. Student and commercial news organizations and groups such as the Student Press Law Center have argued for years that openness in these proceedings is crucial for many reasons. First, students aware of crimes on campus will be more alert and thus safer. Western Washington student media, reflected by stories written by some of the students here today, have committed themselves to making sure that Western students know more about crimes that occur on this campus and how those crimes are being addressed. Second, the accused and accuser have no guarantee of fairness in a closed proceeding. We got rid of star chamber justice systems in this country a long time ago. We decided we don't like people judged behind closed doors with no opportunity for public oversight. Yet curiously, we allow such systems to operate on campuses across the country in 2019. Open campus courts, like open public courts, would engender trust between students and campus officials, limiting accusations of cover-ups or favoritism or incompetence. Finally, let's focus on the specific information being sought by this lawsuit. The plaintiffs are seeking just the final results of disciplinary proceedings where Western Washington University has determined that a student was responsible for a crime of violence. That's it. It's information that would be routinely available from a public court, along with much, much more, if the case involved a 21-year-old non-student. If schools like Western are going to take on the responsibility of adjudicating serious crimes in these vehicles called campus courts, it's time that we, the public, got a better look at what's under the hood. Hiding information about campus crime behind a law intended to protect student grades and test scores is bad policy. This lawsuit helps to fix that. On behalf of student news media across the country, I thank Erasmus and Julia and Asia, and of course their volunteer lawyer, Bill Crittenden, for taking a stand. Thanks. Take some questions if you guys do.
Since you're mic'd up, I think we'll start with you, so we don't have to move the mic. So, do you want to start, Raji? Okay. Can you talk a little bit about the law that the university is citing? They're saying that they want to. There's a privacy violation here if they were to release those names. But as Julia mentioned, the University of Washington already does this. So can you talk about the law that's in place and how they're trying to use that to protect those names?
Well, they started when they first initially asked for the records. They started by citing the federal law, the Federal Family Educational Privacy Act, despite a clear amendment to that law saying that the information that they were looking for is absolutely available. And so then, under FERPA. Under FERPA, correct. Yeah, there's a very clear exemption that says that crimes of, if a case involves a crime of violence and if there's been a finding of guilt, information about that can be released without violating FERPA. And so then they fell back on the state law privacy exemption. But again, there's some pretty clear case law that makes it clear that this law was intended to protect student academic sort of records, students' records that were put into a student's file for the benefit of the student. It was never intended to protect things like this, where we're talking about felonies, we're talking about criminal actions that the court is hearing and making the decision on. So their use of these laws to prevent access to this information is misplaced.
When you look at how the campus court works. Are some of these cases we're talking about, were they tried criminally outside of Western
Not
Washington?
always, yeah. Sometimes that's the end of it. I mean, the case is, it's a sexual assault or a robbery or something like that. The case is brought into the campus court system, and that's very often the very end of it, and that's the last we hear, especially if there's a finding of not guilty or not responsible. I mean, that can be just the end of it. We don't hear anything more about it. So there really is very little accountability for handling matters that typically are very much handled in the public.
I mean, but if it was handled in a regular criminal court, the names would be public, rendering the whole effort moot. Is that correct?
Correct, absolutely, yeah. So I mean, this is kind of a bypass. This is a way around having to have these things handled in the public, and sometimes I think that's intentional. I mean, the university gets to control the information when they handle it in these closed campus court systems.
What's the liability?
Go ahead. No, go ahead.
What's the liability that the university is citing that a perpetrator may sue them if they release this information?
I think they're claiming that the
That was under FERPA, yeah.
the Public Records
Yeah,
Act,
they specifically said they were concerned about FERPA. Yeah.
You good? My last question to you. I hate to sort of put it this way. Do you see this sort of as kangaroo court? I mean, is this something that
They can be, yeah. I mean, the problem is we just don't know. I mean, we really don't know what happens behind these closed doors. On the occasions where there have been, there have been journalists that have been able to get behind the closed doors. I mean, some of the stories that come out are very alarming, and I would call some of the things that have happened, and some of those situations kangaroo courts, or certainly not the sort of justice system that we're used to. The problem here at Western, we don't know. We just don't know exactly how it's being conducted, and that does, that raises some questions, both on the part of students that are judged under the system, and I think, it helps the school itself when they're more open and forthcoming about how it's all being done.
Do you know who you are?
Yeah, my name's Erasmus Baxter. That's spelled Erasmus, Baxter, Baxter. And I'm a senior journalism major here at Western.
And you're one of the plaintiffs, correct?
Yeah, that's correct. It's me, Julia Furukawa, and Asia Fields.
My first question to you, Erasmus, is kind of more of an emotional one. Did you think it would come to this?
We really hoped it wouldn't. I mean, we gave the university every option to try and avoid this process. This process began 2 years ago, right? And what started this was me reading the law and realizing, oh, they made a mistake. They're going to want to correct this. And so when we reached out to the Public Records Office, I thought they would check the law, see that they'd made a mistake, and then release the names. And that's just not what happened. At every turn we're being met by obstruction. And in fact, even before we filed this lawsuit in October, we met with Vice President for Student Life, Melinda Husky, to say, we don't want to do this. We offered the opportunity to meet with Mike, who has the expertise on this issue. And, our position has been that the university is making a mistake. They're misinterpreting the law. And we want them to correct that. And, we hope that they would recognize that and do that. But apparently not. And so that's why we're here now.
But you do believe student privacy is important.
Oh, absolutely. I mean, I'm a student. FERPA has an important purpose for sure, but also, the ways that it's being applied, the law is the law. The way the law was created, if you look at the congressional record, they specifically carved out an exemption in FERPA for cases of violent or sexual misconduct because they were concerned about transparency and about safety on campus. And so while, it's good that educational records are kept secret, students have a right to know, and students want to know if they're safe on campus, if these systems are working the way they're supposed to, because these are systems that basically impact people's lives and their ability to get an education.
Can you take a step this way for me? I'm trying to get you. There you go. I'm trying to get your sign in on you. Can you talk about just interviewing and talking with your fellow classmates about their experiences having to walk on campus with the person who was found to have sexually assaulted them?
Yeah, so Asia Fields, who's the other plaintiff, did a lot more work on this. And if you want to look up her reporting, it's put the Western Front of the AS Review. But what we heard from students, particularly one student in particular, Tia Petrini, who we mentioned, who was sexually assaulted. I mean, she had to face the man who had hurt her every week on campus on her way to class. And, that impacted her education. She had to avoid him on the way to class. She was leaving class early. And the reason for Title IX is because to ensure that there's an equal access to education, and that's clearly not what's happening there.
Do you feel like you could be sitting in class with practically anybody that might have done something horribly wrong and you wouldn't know about it?
That's something we've heard from students. When we first reported on a case of a student who had actually been convicted of sexual assault in the criminal justice system and then returned to campus without anyone knowing about it, we heard from a student who was also in the same visual journalism major as them, and they were talking about how you have for the class, the capstone class is a senior visual journalism class, and you spend a lot of time on like a one-on-one basis with people. You spend a lot of time traveling around, and she was concerned that, you know, this person who was in that major, she didn't know anything about them. She didn't know anything about their history, and so she was definitely concerned and said she wouldn't feel comfortable being with someone in that class if she knew about that history for sure.
Students are afraid.
Some students are definitely concerned for sure.
Where do you think this is going to end up? Do you feel like that this is going to be a long, drawn-out battle, and what do you see for happening in the future?
Our hope is to solve it quickly. I mean, here's the thing. It's like Western's making a choice. Any day they can release those records, any day they can end this lawsuit, and every day they delay is more taxpayer money and more student money that's going to cost them when they inevitably lose this lawsuit at the end of it. So our hope is, you know, they could resolve it tomorrow, and that would be great with us. We're not in this for the money. We're not in it for anything. We're journalists. We want transparency. We want the names. We want what we're legally entitled to.
Talk to me about just kind of realizing how little the university was telling and sharing, and how the lack of transparency, and what that meant for you, not just as a journalism student, but just a student walking on campus.
Well, I wasn't one of the folks who initially reported on this. I was brought on board later as an editor of the Western Front, so I can't exactly speak to the stories of the folks who were initially interviewed. But I think Erasmus phrased it well. There's a concern among students that we don't know how these processes work. They operate behind closed doors, and there may be folks who have been found responsible for this type of conduct on campus, and that's something that the student body who pays money to go here and who come to campus every day for an education deserve to know. Like Erasmus said, we have asked repeatedly from the administration for transparency. It's not that we want to expose people or list all their names online. It's that we want to see if there's trends. We want to be able to quantify this. How often does it happen? And what are the conclusions that they're coming to?
And you found that some of the students were suspended or removed from campus for a year, and then they were able to come back. Is that one of the trends that you're able to find from the little limited data?
Would you be able to speak to that?
Yeah, I guess I could speak to that. I'm not.
Well, it's okay. Go ahead.
Yeah. Yeah, that's something we identified. We found two particular cases. The first case where a student had been convicted of sexual assault and returned around 2 years later to campus. But in the second case I spoke about, where the survivor was still on campus, that not only was the student found responsible for sexual misconduct, they found that they'd actually concealed a previous juvenile sex offense that they'd had to go to sex offender treatment for. And knowing both those facts, they decided to readmit the student to campus, and they came back, I think it was something like 2.5 years later.
Anything we missed that you wanted to make sure that students or the general public understood?
I think one thing that's important to be really clear about is we're only looking for the names of students found responsible for sexual misconduct. So if there isn't a finding, the name won't be released, and also the names of any students involved in the process, besides the student found responsible, are still going to be confidential. And the law allows the university to withhold information that would allow someone to identify survivors in those cases. So what we've heard from survivors we've spoken to is a concern about greater transparency on campus, because they're not seeing that and they want more accountability, but there's no need to be worried that the identities of survivors or other vulnerable people would be threatened by this.
And that was a concern that was cited by the administration, that they had a fear that should they release the names of those found responsible, they would a person would be able to figure out who the survivor was. The standard for public records is that information is redacted if a reasonable member of the community would be able to identify who that person is in the records. And so if you were already close enough to the case, you would probably know. We're trained to be responsible with our reporting, and that means that if we knew the identity of a survivor, we would never release their name without their express consent and speaking to them first to get their side of the story. That's something we would never do. So concerns about survivor privacy are absolutely at the forefront of our minds, but we're asking the school to be transparent with their processes and hoping that they trust us to hold up our standards of reporting.
Why is it only sexual in nature? That why not battery, assault, robbery, or other forms of heinous crimes like that?
So that's actually included under that. The specific statute is violent crimes or sexual offenses. So assault, for example, would be included under that. The reason why we're specifically focusing on sexual misconduct is because, like in other universities across the nation, we've seen issues with the way those cases are handled at Western specifically. And there's a lot of different factors, cultural, systemic factors that have led to that. But we've seen a specific issue with this system, and that's why we're investigating it.
Yeah, I'm good. Thank you. Is it more likely you think that like a robbery or something would be reported to the authorities outside of the university versus like a sexual assault perhaps?
That too, yeah. And also, to be completely honest, we think the university does a better job of understanding the severity of those crimes as opposed to sexual assault. Yeah.
Thank you.
Thank you.
Appreciate your time.